Good afternoon, everyone. I know it's not 12:30 yet. Okay, it's 12:30 now, so we're just gonna get started. So good afternoon, everyone. My name is Oluwatobi Akiwande, Toby for short, and we're here doing a quick question and answer session. Can you hear me?
Oh yes, Toby. I think we lost you a little bit there, but yes.
Do you hear me? Okay, that's great. So my name is Toby, like I said, and I am a family and childcare solicitor in.
Toby, we've lost you again. I think your sound keeps coming in and out.
Can you hear me now?
Yeah.
You can hear me now. Okay. So I was saying, introducing myself again, that I'm Toby. I'm a family and childcare solicitor and supervisor and I'm based in the Birmingham office at Duncan Lewis Solicitors. And my colleague is the director, Sophie, and I'll just pass it on to you to introduce yourself. Thank you.
Thanks, Toby. And hello, everyone. Thank you so much for joining us today. So I'm Sophie Bircher. I'm one of the directors here at Duncan Lewis, and I head up the family mediation department, as well as being a childcare and family solicitor. I'm based in the Luton office, but I also work from Birmingham and also from our city office. So I can offer both legal and family mediation services from a variety of our different offices. As I say, I specialise in childcare law. Children Act matters are my kind of area of expertise, as it were, and I'm a member of the Law Society Children Panel as well in that respect. But I'm also a resolution trained family mediator, trained in all issues. So that relates to arrangements for children, finances and property upon separation. And it's really in that capacity that I'm kind of talking to you today. But I mean, I think the reason why we've linked it with today, it's Family Mediation Week this week, throughout Monday to Friday. There is a huge array of great seminars and really information sharing. The aim of the week is which is run by the Family Mediation Council, and also Resolution have a big involvement in that. But the aim is to bring a greater awareness of family mediation, of the process, its benefits, and its potential as one of a number of means of resolving disputes without the need to involve the courts. So it's about sharing information and really building that awareness to the public, but also to professionals working with families and separating couples. So, as I said, there's a wonderful timetable that the Family Mediation Council has put on this year, and it's been a great week. There's been a huge number of talks and sessions. But so Toby and I really just thought it would be helpful to link in with that and really just have a little chat ourselves to share our knowledge and experience and a little bit of information that we hope might be helpful to everybody. Also increasing awareness of what Duncan Lewis is able to offer.
Yeah. That's great. Thank you so much for that, Sophie. So what we're going to do now is we're going to run through a list of questions that has been prepared just to help, clients, future clients to understand the mediation process and how to come to us for assistance if they need any assistance. So Sophie, I'll be asking you a few questions, and as you're mediating yourself, you'll be able to answer them. So I'm just going to start now, okay? So Sophie, what is mediation, and more specifically, what is family mediation?
Yeah, so I mean, mediation is ultimately a way of attempting to resolve issues or disputes that have arisen following or during a separation. The hope is in a more amicable, cost and time effective way. It enables a way of looking forward positively in a very child-focused way, and that is very much the focus, certainly where children are involved. It's central. But looking at the possibility of you as a separating couple or a separating family to come up and find a way to put forward and come up with some proposals that are tailor-made to you, to your specific situation. Mediation as a process, and certainly the mediator as the facilitator of that the process, the manager of it, provides the opportunity for really a safe space to be created for the separating couple to have that confidential safe space to engage in what are really difficult conversations at a really emotional time, really personal things that are being discussed. It's talking about things that are most important to you as a person and as a separating couple, at a time, as I say, that's often one of the most difficult in your lives. So the mediator is there to manage the process and to guide discussions between the parties, and manage that process. But it's your process, it's your agenda, it is whatever you guys feel is important and is relevant to your family situation. So mediation is about looking not at what is right or wrong or what the law says should happen. It's about what is right for your family, and it's guided by and kind of in the concept of what may be considered fair or appropriate by a court if it were to progress in that way. But it is what is right for your family. It's that tailor-made, and that's one of the huge benefits of mediation. Excuse me. Mediation is also being proven to be consistently a time and more cost-effective way of resolving a dispute, without the need to go to court. Much I'm not going to sit here and say it's still not a stress-free process, but it's certainly acknowledged to be less stressful and far less acrimonious than having to engage in full court proceedings.
Okay, that's great. Thank you so much for that detailed explanation and definition of mediation. I know a question I always get asked often are questions about why should clients try mediation when they can easily make an application to court and get the judge to make like an order? So why would people need to try mediation?
I mean, ultimately, following some changes to, I won't go into the details now, but following changes to the family procedure rules that govern court processes and court applications. And really, it's based on the recognised benefits of mediation and other forms of non-court dispute resolution. But it is now a requirement before any application is made to the court in respect of a financial matter or in respect of arrangements for children. It is a requirement that the parties have to show that they have tried to resolve matters without the need to go to court, and that they have attempted or considered the appropriateness of an out-of-court resolution, and mediation obviously is where that kind of fits in. So unless a person is able to satisfy an exemption to the requirement to engage in mediation, and I'll come on to that a little bit more, because I think that's kind of an area of its own. But really, if there's a safeguarding reason or an urgency to the need for that court application to be made, then there is a requirement to attend a mediation information assessment meeting. And that is to allow the information to people to make an informed choice about whether mediation might be something that can help them resolve the issues that have arisen, as I say, in a much more amicable way and without the need to inform the court, and obviously the associated costs and time implications that has. But kind of putting that to one side, I suppose, not everybody wants to go to court. You know, there are occasions it's stressful, and I think a lot of people have a great deal of anxiety, but they don't know what the other options are, and they don't know that there is another possibility. You know, it may be that they're kind of stuck on certain aspects of saying, well, I know I really want this, I think this is the best way forward for my family or for me during the separation, but I know that he or she, the other side, won't agree to that. Often, you know, separating couples, however acrimonious that separation is, they're able to kind of, get to a point where maybe some things a compromise is reached, perhaps, but there's then some issues that are kind of stuck on. And it's really just, as I say, mediation is one means of just trying to unstick and give that safe space and that kind of extra push and extra opportunity to explore whether discussions and proposals, mutually acceptable proposals, can be reached. It also allows parties to feel more in control of the process. Often feedback, and certainly, as I say, I've got the benefit of seeing it from both sides, but as a solicitor, the feedback I get is that, well, I know I said that that's what I wanted, or but the judge didn't really seem to take that right on board, or they took that right on board. There is still an element, obviously court proceedings are procedural, they follow certain steps. Mediation allows parties to feel much more in control. These are really important decisions and discussions that relate to you, and they're personal, and mediation gives that opportunity, that tailor-made kind of outcome. Is the hope. As I say, these are decisions about things that are the most important to you: your children, your property, and your money, hard-earned money often. And really, that is the feedback, as I say, is that just having that opportunity to remain or feel that you're keeping control of those decisions, rather than just being told by a judge, for example, or professionals that have been asked to kind of come into your lives and to assess things, but you're being told what should happen. Yeah.
Okay. So thank you so much for that. So I know you said mediation is a way for the parties to be in control, and it removes a lot of animosity. So what actually happens within mediation?
Yeah, great question. Great question. So as I say, mediation is tailored to you. So it's you that sets the agenda. All right. It's about the issues that are most important to you and about you and your family's needs. But that said, as a general process, it does depend who I'm approached by, or kind of what stage you are at potentially in the separation. If I were, for example, approached by one person to say, look, I've separated, there's these issues, we just can't agree amongst ourselves. I don't want to go to court, but I think I might have to, because I don't know how else to get to the bottom of this and to resolve it. The first step then, I would be, as I say, there is now a requirement before any application is made to the court to attend a MIAM, a mediation information assessment meeting. So I would invite that person to attend a MIAM, to enable them that opportunity to obtain information about mediation and the process, and out of court dispute resolution means, and what other options might be available to them. And also for me to assess the suitability of mediation as a process, and whether there's perhaps any reason why it might not be appropriate for them in their circumstances. Once I've held a MIAM, that initial mediation meeting with that person, there is a requirement for me to invite the other party also, to give them that similar opportunity to have those discussions, to receive that information, and for them to consider whether they would be willing to engage in mediation with the other party. Now, one of the huge principles of mediation, it's central, is that mediation is a voluntary process. No one can be forced to engage in mediation. And you have to come to it willingly. So if having done an initial MIAM meeting with both parties, if there is a willingness or an acceptance that this might be an appropriate process for us to avoid the need to go to court, then, and both are willing, and I am, as the mediator, I'm satisfied that there's no reason that mediation isn't appropriate for them, there's no safeguarding issues, etc., then I would arrange an initial joint meeting with those. And it's, excuse me, at that then I'm saying, right, you're setting this agenda, what is it that you want to discuss? And the mediation process kind of really, in essence, starts with more full force, as it were, really. If having attended that initial MIAM and perhaps invited the other party, but they're not, either they don't respond or they're not willing to engage, then as long as that initial meeting has been conducted in a in an appropriate way, which any mediator would be if it's been conducted as a MIAM, that then allows the court form to be signed, the appropriate form to then enable a court application that kind of satisfies that exemption and says they've attempted mediation, but it's either not appropriate or it's not progressed. If I were approached by both parties together, perhaps, or even if it's one party that are saying, look, I've spoken to my my separated, either my ex-husband, ex-wife, whoever it may be, and we think that mediation might be what we need just to give us that kind of additional assistance, then the process is still the same, but obviously the invitation to the MIAM is almost a moot point because they're both already attending. So the MIAM it still is required because it's that initial meeting about information, about mediation, the process, and that sharing of information. And it's really key also for the mediator to help understand, what each party is, what's important to each party, what they're both trying to achieve from mediation. So that helps us manage the process. But almost at that point, I can arrange both the initial individual meetings with each of them, plus the joint meeting, knowing that it is going to progress.
Okay.
And then I suppose the only after that kind of initial joint meeting, then it's really, as I say, it's your process. So it's however many joint meetings are required, whatever timescales that might need to be on for you, depending on the issues that are being discussed.
Okay, so thank you so much for that. So what kind of issues can be discussed or can be dealt with within a mediation process? Yeah,
I mean, anything really, as an easy kind of quick answer, anything that is important to the parties. The standard issues, as it were, I suppose, are finances on separation, and how that can be as simple as just the sale of a house, so that involves property, in respect of maintenance for the children and what that might look like or might be needed. And coming down to pensions, looking at the future. So yeah, finances, property, and then arrangements for children are really the kind of the core, I suppose, broad topics. But really anything that is important within those umbrellas. So it can relate to really tiny things about a holiday that's proposed, and how that might look, or what each of them feel comfortable or not comfortable with. Any topic or issue that the parties wish to bring to mediation. So whatever is important. I know many of my mediation colleagues have mediated in respect of arrangement for a dog or a pet. It really is. It's your process and it's tailor-made to what's important to you.
Okay. And that's really good then, because then I think it opens a way for parties not to be scared and not to feel scared to engage with the process, because they have to go through that process anyway before going to court, don't they?
Yes, exactly.
Okay. So you being a mediator, what is your role? What do you do?
Yeah, so it's very key. I mean, the mediator is independence and impartiality are, I guess, the key kind of the principles of mediation and of being a mediator. The mediator is not there to tell them what needs to happen or what should happen. Okay. The mediator is there to oversee and manage the process that allows, as I say, two or more people, if there are relevant people that need to be joined into that process, then again, that can be incorporated. But it just allows the people to sit down together, to have conversations that are really difficult and highly emotional, but knowing that there is an independent person there to manage that process and really to rein them in if needed, and to really get them back on track, but to try to help them to find a positive way forward that works for them. I often get asked whether a mediator is trying to help the party save the relationship, and no, and that is not that is certainly not the aim of mediation. That's a counsellor, and I'm certainly not trained in that respect. But, we're not relationship counsellors, but the intention and the aim of mediation is not to save the relationship. It's forward focused. It's to save your future, particularly if there are children there, and to ensure that you're both, if this is the decision that you've made, i.e. to separate, then that everybody can, or that can be done in a way that is as mutually acceptable to you both as possible, and that works, as I say, for you and your family. So yeah, it's to attempt to resolve some or all of the issues that might have arisen because of your circumstances and your separation, and to do so in a way that kind of minimises the distress as much as possible, particularly for any children, and that promotes and maintains a good relationship moving forward, particularly, again, if there are children. That's so important.
Okay. So what happens if you have two parties that cannot agree on anything? What does the mediator then do?
I mean, I would like to say that we're, miracle workers, but mediation doesn't and cannot hold itself out to be a magical solution to all disputes and difficulties. It can't guarantee resolving those issues, but it allows the opportunity for those difficult discussions and highly emotional topics to be explored, to see if there is an opportunity for mutually acceptable outcomes to be reached. So it may be that the mediation process is only able to address some issues. It may be none. But it allows the opportunity and that attempt to be made, and it may, even if an application is still necessary to the court, it allows certainly the court to be aware that these issues have tried to be resolved, and whether they've been narrowed, great, that can be obviously set out for the court, or why these parties perhaps are stuck. What is it that's still there? It may, as I say, may have narrowed the issues, may not, but certainly it's given that opportunity and in a time and cost-effective way.
Okay, that's great. Thank you so much for that. So a reversal to that question I asked you, what if the parties are then able to agree everything? What happens? Is it legally binding? Do they sign off on it? What happens?
Yeah, so and that's really key. Any outcome reached through mediation and any proposals made or accepted reflects the intentions of the parties, but they're not legally binding. All right. That said, it's very easy to ensure that they can be. All right. And it's open to the parties to record proposals that are reached and to submit a draft consent order to the court for the court's approval, which makes those arrangements legally binding. And it's for that and other reasons that it is really important that mediation is always certainly it's always advised by a mediator. Any good mediator would refer to a solicitor as well, but the balance between and the overlap of mediation with the benefit of having independent legal advice is really key there, because then obviously it can then kind of pass back over to the solicitor to do those final kind of bits to ensure it's legally binding.
Okay.
Yeah.
So that answers just led me on to the next question. You know how you're saying getting like an independent solicitor, but also having a mediator help with the process. So what is the difference between a family solicitor and a family mediator? Would a party, when they come to you, would they need to have both a family mediator and a family solicitor?
It's a great question, and one that I get all the time, because I think the distinction, isn't necessarily known. As I say, this Family Mediation Week that's ongoing at the moment is all about building that awareness. But ultimately, a mediator, even if they are legally trained, for example, like as I am, cannot give legal advice during the mediation, okay? Because you have both parties, and we are independent and impartial to the process and to the outcome of it. So the mediator must remain neutral as to both, as I say, the outcome and the discussions and where they are going, and independent to either party. So a mediator provides information, all right, but never advice. Now, the information that a mediator can provide may include how a court might view proposals, for example, in respect of a financial settlement that's made by the parties, but it's the parties' proposals. They would never give legal advice to one or both parties. Okay, it's about sharing that information and or signposting to appropriate people. Whereas a solicitor acts for just one of the parties. Okay, a solicitor could never represent both because that would be a conflict of interest. So the solicitor's role is to advise their client, their party, about the law and about how their case might be viewed in light of the law, i.e., strengths and weaknesses of their case. They act for their client's best interest, so one party's best interest, and on their client's instructions. And obviously their aim is to get the best outcome for their client. The mediator's aim is to get the best outcome for them as a separating couple. So I hope, that's probably kind of the best way I can explain the distinction, but also that's why obtaining independent legal advice is always recommended, particularly in respect of proposals reached at the conclusion of any process, before and if it is then to be set out and formalised by way of a consent order, for example. So mediation helps and allows people reach the outcome that's theirs and that works for them in a more amicable way, and then the family solicitor kind of during that process, if parties are able to, and I appreciate, there are cost implications, of course, but if a family solicitor can be involved in that process and meet with their clients, after joint meetings, before joint meetings, so that it's really about the parties that are engaging in the mediation to be as informed as possible. So if they know what their rights are, for example, or what they're thinking, how a court might view what they're thinking when they go into a joint meeting, then that really helps them also feel in control and to make those informed decisions, and know where they want to compromise, where they're able to compromise, and what might the alternative kind of be, really. So yes, ideally a person would have both throughout the process, but certainly at the end and in respect of financial settlements, it is very, very much advised that there is legal advice, independent legal advice for both parties from a family solicitor that kind of ties in and merges that process. And a good family solicitor will always refer to a family mediator and vice versa. So, yeah.
Okay. That's great. Thank you so much for that. So in terms, obviously, we've been speaking about family-related matters where separating couples are involved. So what about when they have kids? How can the children be involved in the mediation process?
Yeah, and this is key. I mean, one of the main principles of mediation, the welfare of any children of a relationship is central to the mediation process. And the focus on the child's needs and interests, a mediator has to ensure that remains central. Excuse me. It's so important to ensure that the voice of the child is heard and is kept at the forefront of the parents' discussions, and that they can remain focused on that. And all the decisions and proposals that are being put on the table are influenced and led by what any children are saying or how they're feeling, how they're presenting. Obviously, it varies hugely depending on the age of the children and the circumstances. But again, the benefits of mediation in terms of being able to tailor it to the family's needs and the children's needs, ages, circumstances, for example, it just that all plays in, really. So any opinions expressed by the children are really relevant. Although that, of course, in itself might be an issue of dispute between the parties. You often have one of the parties in mediation saying, well, the children are telling me this, and the other one, well, they're telling me this. And certainly over recent years and now there is a huge push. There's a really, really valuable kind of form of mediation that's developing all the time, but is really coming to the forefront at the moment. And it's really centred around how children's views and wishes are to be dealt with, and how involved the children should be in the process. There is now the option of child inclusive mediation. as I say, it's a growing and really crucially important area. If a child of the family is capable of participating in the mediation process, then it's acknowledged that they should. Now, any mediator that is offering and providing a child inclusive mediator has very rigid and specifically trained in that. As I say, it's an emerging area, but any mediator, even if you perhaps start the process with a mediator that isn't a child, that doesn't have that training, and another, you can almost co-mediate, you can bring somebody in to that process that can then involve the children. And that really varies. It's kind of acknowledged around the age of kind of from 10. The child's, they do have views, they do have wishes, and particularly if this is instead of and allows the court proceedings to be avoided, it still means that the children can be involved. These are decisions that are being made about their future, so where possible they need to be involved.
Okay, that's really clear. I know, like, so far now we've spoken about what mediation is, what the process involved in mediation, the difference between a family solicitor and a family mediation. Now let's talk money. How much does it cost?
Yeah. It's crucial. It's really important to people. They need to know. I mean, I can't give a definitive answer as ever, and that's a cop out. I appreciate, but it depends on so many factors. Not least the number of joint sessions that parties choose to arrange. It could be that those that the initial individual meetings plus one joint session might be enough for that family. For those parties to just kind of really consolidate. And review everything, and they're saying, right, okay, that's enough for us. We can now, that started us on the positive process, we can do this ourselves now. In others, then it may be, you can have 3, 4, there's no limit to the number of joint sessions. Obviously, as the facilitator and the manager of the process, the mediator may just say, look, we've got to a point now that we're not like to make any more progress. But obviously the longer the process is and the more meetings, the price, obviously, the costs do increase. Also, if there's any additional experts, or if there's complicated financial matters and you're needing, for example, a pension expert, there are going to be the additional costs involved with that, including also, I've referred to child inclusive mediator. If you need someone else to come in and kind of chip in and give that advice, the costs are obviously all going to be affected by that. Now, legal aid, I know, again, that's another question I'm asked regularly. Legal aid is available for mediation in some circumstances and subject to financial eligibility, as is help with mediation, which is really relates to the legal advice that relates to mediation and legal advice alongside the mediation process. Again, financial eligibility is relevant there, but so there are options that can be explored. Otherwise, there are many firms that offer fixed fees. And very competitively as well, Duncan Lewis, of course, being one. We offer competitive fixed fees for both attendance at that initial MIAM meeting, so that's just the standalone kind of one-off meeting, but also in respect to the substantive process, if it is something that you can progress and move forward. And our fixed fees start as little as £120 plus VAT. So it's, we're looking at, as I say, the benefits of mediation do include the costs, much lower than court proceedings, which unfortunately regularly extend into thousands of pounds. So
that's true. So I know you did say that there is no limit to the mediation process. So, and I know you may not be able to give me a definite answer, but how long does the mediation process take?
Again, as I say, it depends on the number of joint meetings. It depends on the length of time between those meetings. Mediation, and again, in direct conflict to court processing, but mediation can be set up and started really quickly. Okay, and that's one of the benefits. It's you're not having to, give your instructions to your solicitor, prepare all your documentation, lodge it with the court, and wait for a hearing date. If everybody is willing and able, and there is no reason why mediation isn't appropriate, those initial individual meetings and the first joint session can be arranged really quickly, within a couple of weeks. In terms of the kind of the timescales and the total length of time, as I say, does depend on the number of joint meetings.
Okay.
Also, the program, like how quickly your process needs to go. Now, often we find, particularly where you're talking about arrangements for children, if proposals at that initial joint meeting, if proposals have been possible and there's a kind of plan, all right, it may be that I kind of say, look, let's go away, let's go 3 months, let's try this, and we're reality testing. It is how I always refer to it. It's great when you're sitting in the room, you're talking all theoretical, but it's what works in practice, and how the children react to that as well. Do those arrangements actually, they look great on paper, but do they work in reality? So perhaps 3 months, for example, allows that time to kind of embed arrangements, test them out, and then you come back and say, yeah, this is working really well, but actually this needs a bit of tweaking. So then you do that. And there's going to have been less benefit to coming back after a month, because you're not really going to have had that time for everybody to get used to the arrangements and see if they actually do work in reality. Similarly, in respect of, if you're dealing with financial matters, it may be that you need to go away, kind of press pause while you get mortgage information or pension documents, and those things do unfortunately take time. So that's not really the fault of the mediation process or indeed the court process. It's just it's unfortunately just how things are. But so those things do obviously affect the timescales and how long, if we're doing a kind of start to finish date. But I think the view is that it's all productive delay.
Yeah. I like that term, productive delay.
Yeah.
So, earlier on, when we start asking questions, you said, you can have an individual session with the clients, or you can have a joint session. So now the question is, and I'm sure you ask this question a lot, if the parties have already agreed to attend mediation, why do they have to attend separate sessions initially when they're going to have a joint session together anyway?
Yeah. And I do get that all the time, and it's a genuinely sensible question. Those initial individual meetings are crucial. They're really, really important to obtain and provide information. So for the parties to really have that individual time with the mediator, to give their side of the story, as it were, and to give their perspective, to outline as well what they're hoping to achieve, and also what they understand from the mediation process. I have a lot going, well, yeah, I'm doing this because this is what we can do, and I'm like, that's not really what the purpose of this is. So it's to ensure a mutual understanding of and expectations, what they're hoping to achieve, the issues that are important to them, because they might not be the obvious issues, and when I'm kind of taking background and also giving them information about mediation, all of these type things just kind of come into it. And learning and knowing and understanding their point of view, and allowing the parties to do that individually without really fear of a response at that point. That's their opportunity, their time with me, and really it's for me to build a rapport as well. You need to trust me as your mediator, that I get what you want, and that I understand what's important to you, so that I can then manage the process and ensure that your perspective is comes into those joint meetings and is clear. Now, that one of the key things from those individual initial meetings is that they're confidential. So anything that you tell me, subject to you telling me you're about to commit a crime, for example, or that there's a risk to child, or something from a safeguarding point of view, that's your time to tell me what I need to know. If there is something that's said, if there is something that you're telling me in that meeting that I think is really crucial and central to being able to progress the mediation, then I will tell you, and I will say, I think it's really important that Mr. Bloggs knows that. Do you feel comfortable saying that? And that also leads me, for me, it's a screening process too. I need to ensure that mediation is appropriate and that you and similarly the other party is able and free to make decisions. Okay, so that's from a practical basis, but also emotional. I don't know what you've experienced during your relationship and what the balance of power, control, any of those issues, and it's really important that the mediator is able to assess that. One, to see whether mediation might not be appropriate as a result, but also even if it is appropriate, I need to be aware of that so that I can manage the process and ensure that both parties in a joint meeting are able to express their views and do so.
Okay, well, thank you for that. That's very, very informative. Thank you for that. One question I was going to ask is, in a situation where you have, where you have both parties, what happens if either both of them completely disagree with the process or are hostile?
Blogs knows that. Do you feel comfortable saying that? And that also leads me. For me, it's a screening process too. I need to ensure that mediation is appropriate, and that you and similarly the other party is able and free to make decisions. Okay, so that's from a practical basis, but also emotional. I don't know what you've experienced during your relationship and what the balance of power, control, any of those issues, and it's really important that the mediator is able to assess that. One, to see whether mediation might not be appropriate as a result, but also even if it is appropriate, I need to be aware of that so that I can manage the process and ensure that both parties in a joint meeting are able to express their views and do so.
Okay, well, thank you for that. That's very, very informative. Thank you for that. One question I was going to ask is, in a situation where you have, where you have both parties, what happens if either both of them completely disagree with the process or are hostile or they're not engaging well, or if at least one of them isn't engaging well, then where does the mediator go from there? What happens?
I mean, I think, it's kind of, I've touched on this before, I think, but mediation isn't, it's not holding itself to be a miracle cure, as it were. One of the key principles of mediation is that it's voluntary. No one can be forced or should be forced to come to mediation. It's expected, and indeed it's obviously a requirement now in some respects to engage in mediation or attempt mediation. But that said, it's not going to work if one or both parties don't come to the process at least willing to listen to and acknowledge the other person's point of view. But that said, it is often the case that parties are poles apart when starting the mediation process. It's not a bar to it, certainly, and nor does it mean that it won't work, as it were, or be successful. But the role of the mediator, and indeed part of the skill of being a mediator and our training to do so, is to create that safe space and that neutral environment to guide what are really difficult and personal and emotive discussions. And a lot of the time you find that once you can kind of really acknowledge the emotions and acknowledge the situation and help people kind of relax a little, I suppose, but really acknowledge they're not, we're not there to fight. We're there to forward focus, and that's the purpose of mediation. As I say, it doesn't always work, and it's not claiming to always work, but it gives that opportunity to try to for each of them to express their views and to listen to each other's thoughts and feelings, and to try to enable them to see whether it is something that can progress themselves without the need to then progress to a really much more acrimonious process, and one that they don't have as much control over.
Okay. And I know, like, throughout this session, you have spoken really positively about mediation and, how it's good, it's cheap, it's not costly, it gives the parties, a chance to take control of the situation and things like that. But from your point of view, are there times when mediation is not recommended or isn't likely to work?
Yeah. I mean, it may seem obvious, but if both parties are actually in agreement, they just haven't spoken to each other about it, and haven't actually expressed that, then there needs to be an issue to resolve. Otherwise, mediation that it's not appropriate. There are also circumstances which I've touched upon, but where mediation isn't appropriate or necessary, and it's a recognised exemption to the need to attempt it, and that's in circumstances where there's an urgent need to make the application. So whether that's just in terms of from a time point of view, but also from a safeguarding point of view, and that an application needs to be made without notice to the other party, due to risk to one of the parties or to a child that's involved. If there's been serious domestic abuse, that means that it's not appropriate or possible for a party to attend a joint session. And similarly, in terms of risk to child, if there is social service involvement due to concerns about the welfare of the child, that then goes to the party's ability to be free to make decisions. If they're being told, or if there's bail condition, if there's police involvement, social service involvement, it's not necessarily automatic, but it's something that as a mediator, that's part of that screening process. And as I say, ultimately mediation is voluntary. A party must be able to come to the table freely and ably. As I say, whether practically, i.e. there's restrictions in place in terms of their decision-making powers, or emotionally due to the domestic abuse that they've, behaviours that have been experienced, which means that they're fearful of expressing their views, and therefore a joint meeting's not going to be possible. So as I say, many of those are the kind of recognised MIAM exemptions, and mean that exemption can be claimed when court forms are being completed. Other factors can just influence the mediation, really, and mean that it's not appropriate for them as a process.
Okay. Yeah. Thank you so much for that, Sophie. You've broken down several areas of mediation, and I even understand it now. So no, thank you so much for that. I know that I was looking through the comment and there was a question. The lady, it's me, Malik, says, are there any resources to help prepare for mediation, like guides or counselling?
Very much so. So my first signposting is to the Family Mediation Council website. They have a great just kind of summary of what mediation is and how to prepare for it. Also, Resolution, they have a wealth of resources on them that are all free to download. The separating through parenting separation guides on the Resolution website, it would be my starting point. It's always where I kind of signpost to and send even just an initial inquiry. So that's where I would certainly signpost you to the Resolution website.
Okay. Well, thank you so much for that. I know Sam also has a question, but it's not relating to family mediation. But our team have helpfully directed Sam to our switchboard number to contact him regarding that. But so far, we don't have any more questions. And thank you again so much, Sophie. But I think I'll leave Sophie time to, provide her email address for anyone who needs mediation help. So carry on, Sophie.
Yes, of course. Well, I hope that I'm very aware a lot of information. Obviously, I'm passionate about mediation and its benefits and uses. But if you've got any questions, either on the back of this or any referrals or matters that you're seeking assistance with, please do contact us through our switchboard number, and also or me directly. My email address, I think we'll pop in the comments, but it's sophiebu@duncanlewis.com. Okay.
Thank you so much for that, Sophie. So this is the end of our question and answer session today. Happy Family Mediation Week. Again, if you have any questions, please contact us on our switchboard number, or you can contact Sophie directly. Thank you, everybody.
That's wonderful. Thank you so much for your time, everyone.
Thank you.
Bye.